Welcome to Safe Harbor Estate Law's presentation on how your will or no estate plan may be failing you. I'm Margaret Barrett, the owner and founder of Safe Harbor Estate Law. I am so glad that you are here today because 75% of the people in the U.S. do not have an updated estate plan, or they may have an incomplete estate plan. So you are getting ahead of most people just by taking the first step of listening today. So I'm going to be going over 3 ways your will or no estate plan may be failing you, and I'm going to offer you some free resources that you can get started on to help you move forward. And the best offer will be at the end. That will be a really personal one-on-one, free, confidential meeting to answer personal questions. So keep that in mind as we go through, because I'm sure that you may have questions arise, and we do want to be able to answer those questions for you. At Safe Harbor State Law, we help families protect what matters most, and that is what we do with estate planning. This is most of our team pictured here, and we are available to help you protect yourselves, your loved ones, and your hard-earned assets as well. So that's what we're going to talk about today. We're going to just get started, and but we're going to give you tips that you can take to move forward. So again, congratulations for being here to educate and empower you to make the best decision to protect you and your family. I will never forget how I woke up on March 10th of 1997. The phone rang early, about 6 a.m., and I knew that it was an emergency. In those days, we had landline. I had to run downstairs and answer the phone. And on the way, I thought, it's an emergency. What happened? Who's in trouble? When I answered the phone, it was Barb. She was my first husband's sister, and Joe and I were divorced at that point. So when I heard Barb's voice, I thought something has happened to Joe, that she's calling me 6 a.m. on a Monday morning. And sure enough, Barb said, I don't know how to tell you this, Margaret, but Joe died in a car accident last night. He was 39 years old. I was shocked. It just knocked the wind out of me. And if you've ever gotten a call like that or a knock on the door with that totally unexpected news of a young person passing away suddenly, you know what I mean. It's really devastating. So very quickly, though, my thoughts went to my children, and these are pictures of them at that age. Ben was 12 in this picture, and Monica was 9. And so I had to tell my kids that their dad died, one of the hardest things I've ever done in my life. And I will not forget that either. So the following days and months and years were challenging, because we were not only dealing with things having to do with Joe's estate and things like that, but the grief was difficult. Helping my kids walk through losing their dad was difficult. But what made it really hard on top of it was the estate plan. And Joe had an estate plan. I give him credit. Better than most people, he had an estate plan, and there were good parts of it that helped my children. He set up a good trust for them. But there were 2 problems that caused a lot of trouble. First is he didn't work with an attorney who specialized in estate plans, and so there was a big mistake. The documents weren't signed. One of the documents wasn't witnessed properly, wasn't when it was signed. The other big mistake was he was going through a separation that was going to lead to divorce, and the documents weren't updated for that situation, which is pretty common. So because of those 2, we had years of litigation, 7 years, and it went up to the Minnesota Supreme Court. As my son would say, that was pretty much his growing up years from 12 until he graduated from high school. This was going on. And of course, I tried to protect them as much as I could. They were children, but they knew. They weren't getting their things from their dad's house. They knew some things were going on. And it really strained family relationships that have never been the same. So through this whole experience, I became motivated to help other people avoid the kind of heartache and hassle and expense that our family went through. And I would like you to avoid it as well. So that's why I developed this smooth sailing system, I call it, because there's always rough waters that come up in life, and you don't know when it will be. But whenever it comes up, if you have a plan ahead of time, you can navigate it much more smoothly. And that is what I want to help you with. So of course, we can't go through the whole smooth sailing system today, but we'll go over it briefly and get you started on it. Now, you might be thinking, well, it doesn't really matter. Why is it important? And this is what I would like you to remember. It's your loved ones that make estate planning the most important. This is a picture of my husband and my 3 children and their kids. Now, my husband also has 3 sons, and they have wives and children too, so there's actually 20 in our family. And this is who I think about when I think about not wanting to leave a mess and wanting to protect them and provide for these people that I've invested so much in. And I want you to know that the gentleman holding the baby is my son, Ben. He's in law school. He works at the firm, and he's following in my footsteps. And my daughter on the right, Monica, lives in New York with her husband, Harrison, and they're both doing well. So people often want to know how they turned out, and they turned out really well, thankfully, although, of course, they still miss their dad. So I would like the experience we had with Joe's situation could have been completely avoided, or at least made much smaller than it was. The problem could have been minimized quite a bit, and we could have saved probably, I would estimate, at least $100,000 in attorney's fees. So it really is worth it to plan ahead. And so let me tell you where we're going today. First, I'm going to tell you a little about who I am, because since we're doing this as a webinar, you are not getting to meet me in person, and I really wish I could meet you in person and hope to someday. But I just want to let you know that I am qualified not only by my training in the law, my skills, like my natural gifting, but my personal experiences too have just uniquely fit me for this job. And for instance, my siblings and I have worked together to support my parents. My dad died of dementia in 2019, and now we're still helping my mom. I already told you the story about Joe, that passing away at such a young age. And then also in that, we have a blended family, my husband and I. And so we did an estate plan, especially to protect, because you especially want everybody to still get together for Thanksgiving in the future. So I want you to sleep better at night, knowing you've done what you can to protect yourselves and your loved ones and your legacy and your hard-earned money. It all goes together. So these are some of my credentials. I started the firm 7 years ago. We have like 8 employees now. I won an award for 16th fastest growing law firm in the US last year. And, but we're about quality and service, not just about fast growing, but that's what's happened because people like what we're doing, and we want to build a firm that will last and will be here long-term for you. And I'm involved in the legal community, as you can see, and also do frequent presenting. So if you have a group that you think would benefit from this kind of talk, I'd be happy to hear about that, because we like to present and educate people so they can make good decisions. Okay, enough about me. Let's talk about our roadmap of where we're going today. We're going to go over 3 ways your will might be failing you. And then we know that you're going to have questions, and we're going to provide for you that one-on-one meeting afterward that you can schedule to get your questions answered. Because I've tried to answer questions as we go. I've done this presentation quite a bit, and I can anticipate a lot of them, but you'll probably have more. And so the free resources, we have a couple things we'll email you, and then there's that life and legacy session, we call it, where you can get the one-on-one custom answers for your questions. So let's talk about how your will might be failing you. Number 1, wills do not avoid probate. You maybe thought that if I have a will, I don't have a probate, and that is totally not necessarily the case. Many times a will is probate. Wills are designed for probate. Now, with careful planning, in the right situation, if everything goes right, you can avoid probate with a will. And I won't get into all the details of that, but many times there's a probate. So let's talk about what probate is. You know the expression, you can't take it with you. So That's true. After we die, we can't continue to own property. How does it get transferred out of my name into the name of my loved ones? The court process that helps transfer out of my name into the people who are getting it, the assets name, is called probate. That's basically it, if you have to go through probate. And probate occurs, now I'm talking about Minnesota, if you have more than $75,000 going through your will, like that's not very much, or if you have real estate going through your estate, or if you have minor children often, or there's many other reasons, like if there's a dispute. Those are some of the most common reasons that will trigger a probate. So I want to talk to you about the pros and cons of a will versus a trust, because a trust is the document that is really good at avoiding probate. So very common question I get is, why would I have a trust, or what's the difference between a will or a trust? So here's the pros and cons of a will, some of the main ones. The pros of a will is that it gets the assets to the right people most of the time, because it's going to go according to the will. And if your assets are lined up properly, they'll get to who you want them to get to. It's less expensive now. They're a shorter document, doesn't take as much time to draft, not as many decisions. So it's cheaper because it takes less time. In the short run, it's cheaper. You do pay more later if you have a probate, but if you really are crunched for cash right now, you may be concerned. You want to save money now. The cons are a probate is likely, and it depends on your situation. If you don't own any real estate, if you don't have minor children, if you don't have a lot of money, in certain situations, you're more likely to avoid probate. In other situations, you are going to have a probate for sure. That life and legacy session we're going to offer at the end, that's where we can kind of customize these pros and cons for you and tell you, which ones are really strong for you and which ones to be concerned about. So the probate's likely depending on your particular case. The cost, I would say plan on at least $5,000 minimum. At least it can go up from there if there's any contention, if it's complicated, if there's a lot of beneficiaries, but just plan on $5,000 at least. Time-consuming hassles with wills. I'll tell you, family members don't like doing probate. You have to go through the courts, you have to publish notice, you have to get letters, and it's a complicated hassle. We, of course, do all we can for our clients, but there's still some that they just need to do. It's public. So you'll notice when you file a probate, you start getting solicitations from people like, do you want to sell a house, etc. It's obviously public. And really anybody can access the records and find out what the will says, how much money is in the estate, and who it went to. People don't usually like that. The last con is TODs don't always work. So TODD, that's a transfer on death deed. So what people do sometimes say, I just want to have a will and I don't want to have a probate, so I'm going to take my house. I got 3 kids. I'm going to say, when I die, my house goes to my 3 kids automatically. And if all goes well, you can avoid probate that way. So sometimes it can work, but it doesn't always work. For instance, if my son died before me, or we died together in a car accident, his 1/3 of my house would probably go into his estate, which would go to his wife. And I would probably rather it go to the grandchildren in a trust. In my case, I trust my daughter-in-law and it wouldn't be that much of a problem, but it's not always the case. So if people die in the wrong order or things happen unexpectedly, sometimes transfer and death deeds don't work. So they're not perfect. Sometimes it works and sometimes they don't. Let's go through the pros and cons of a trust. So I put a little basket there because a trust, think of it like a basket. It's going to hold your assets. And so some assets you put in while you're alive and some you put in after you die. But the basket is going to hold the assets, and it's going to have terms that say who gets to manage them and how they manage them and where the money goes. That's really all it is. So one of the pros of this basket that is a trust is that you avoid probate. If it's done properly and your documents are right and the assets are right, you will not have a probate. It's private, so you don't have to worry about any of the information getting out in the courts. It's best for incapacity. Like most adults will lose capacity at some point before they pass away. It could be temporary or permanent. And these give much more power and flexibility to you and your trustee if you lose capacity. Makes it easier for them. Minimizes taxable estate. In Minnesota right now, if you have over $3 million in your estate, then you'll owe estate taxes. And if you're married, a trust can be very helpful to double that limit so that it's now $6 million for the two of you. Trusts also protect from creditors, divorce, and bad financial decisions. So if you have minors or anybody in the family who maybe has a special need or doesn't always make the best decisions, a trust is an ideal way to protect the assets, so it really, truly helps your beneficiary. The cons of the trust: it's more expensive to draft, takes more time, it's longer. And secondly, it takes a little more time to move assets into the trust. However, the cost of a trust is less than the cost of the probates. So that's the pros and cons of a trust. And again, we can meet with you individually and tell you how it will work for you. This is a testimony we had recently from an estate planning client that said the staff was friendly, thorough, and easy to navigate estate planning process, exactly what we're trying to do here. They were going to consider using an online tool or a lower cost option, but they were glad they chose Safe Harbor. It costs more, but the peace of mind in knowing everything is correct was worth it. This was a parent with young children, highly recommending that you take this step to get your plan in place and work with this team as well. And they said, thank you for the great communication and excellent experience. So we really enjoyed working with them, and we're very happy that they are happy customers. So this time for action slide, when you see this is something that where you can take action after this and it won't cost you anything. We have a navigation plan we developed. We give it to our clients after they're signing, and we thank you for listening today. And so we offer this to you for free. So you will be getting this afterward by email by virtue of signing up for this webinar. And it's about a 4-page double-sided form that you fill out information of where your documents are, who are the people to contact, passwords, things like that. We'll send that to you. And if you complete that and make it available to your loved ones, that will be a really helpful resource for them. Next, we're going to go into reason number 2, why your will or your estate plan might be failing. Remember, the first one was you may not avoid probate. Okay, this second one, your assets may not go where you want, even if you have a will that says that is correct. And how can this happen? Well, I'll tell you, I had a client who had one brother and his dad died. And so his dad had a will that said 50-50, fair and square to each brother. And then he put my client on the checking account and his brother on the savings account. Okay, so when he died, they each got these different accounts. And then he made the brother, not my client, the personal representative or executor. So he was in charge, after dad died. Of course, what the brother did was pay all the bills out of the checking account, which went to my client, instead of out of the savings account. And so these assets didn't even go through the will. It didn't really matter what the will said, because the dad made these accounts go directly to his 2 sons. And then the one he picked as personal representative was rotten and paid all the bills out of his brother. So my client got about $2,000 and his brother got about $20,000. And really, my client would have got less. I mean, I lobbied to get him $2,000. And after that, his option was go to court and fight over it. But he said, I'm not going to speak to my brother again anyway, just drop it. So that is an example of something happening that was not what the dad wanted, I'm quite sure. Another example is these 4 sisters here. This isn't really them, of course, but two sisters came to my office because their mom had died. This was last year, 2019. And one sister died about 2 months before mom, and one sister died about a month and a half after. I mean, it was terrible and unlikely, but that happens sometimes. So she had a certificate of trust at a local well-known bank. And she put on there, a certificate of deposit, a CD. And she put on there for the beneficiary designations, all 4 of my daughters equally, and if they predecease me, to their children. And so they thought it would go that way, divide it in 4, and it goes to the 2 living sisters, and the 2 deceased sisters, it would go to their kids. That's not what happened. Because even though the beneficiary designation was A-OK, the terms of the certificate of deposit, which nobody reads, said if a beneficiary dies before you, their share is zeroed out. It overrode what she said in the beneficiary designation, and they didn't tell her this ahead of time. So the sister who died first got nothing, and then the other 3 divided it up. And so the people who had just recently lost their mom got nothing from grandma. There's nothing the client did wrong. It's just that beneficiary designations, they don't always work. Trusts work, but beneficiary designations do not always work. So I want to teach you just a little bit here. I want you to understand how assets transfer at death, because remember, you can't take it with you. How is it going to get from my name to someone else's name? One way is beneficiary designations. I just talked about, on your life insurance. It's called POD sometimes at your bank account and your retirement accounts. You're probably familiar with those. The second way is ownership. So if you own your house jointly, say with your spouse or a child, when you die, they're going to own it. These are fairly automatic. You file a little paperwork after they die. I'll provide a death certificate, but then you'll get the money. They're pretty automatic. The next 2 ways are not as automatic. There's probate, like I told you, that's the court process to transfer out of your name, and a revocable trust, which avoids court, but your trustee will transfer it. So with those, you need to do something. The personal representative for the will or the trustee for the trust needs to transfer those assets. So the takeaways I want you to remember are 2 from this point. Beneficiaries and joint owners both trump the will. So your will might be just right, but if you don't have your assets right with the beneficiaries designated and them titled rightly, properly, then it can undermine your plan. And most people don't know that. So as part of the smooth sailing system, we don't just get you good documents. We also will make sure that we have all your assets, we know what they are, and we coach you exactly on how they should be titled and provide the support you need and walk you through it so that your assets match your documents and you don't get any surprises later. Time for action again. If you'd like, the action you can take is to complete our asset summary. This is something we do for all our clients. It's very important and critical to this step in the process. And we'll send you a blank Excel sheet that you can start putting it in, because just really even finding your documents, knowing what your assets are, how they're titled, it's going to be important when you meet with an attorney. It's going to be really helpful for your family if something happens to you. It might even be helpful for you in the meantime. So we will also send that to you as a thank you for watching today. Okay, and here's another quote from a client that worked with us. Very pleased with the way Safe Harbor's working with us. The information is understandable. That's what we're trying to do, and helpful as we think through the details of our trust. You're not condescending and don't overwhelm. That's my goal, to not overwhelm. So they were glad they chose us also to help with their estate planning, and this client chose a trust, which honestly, I think at least 70% of our clients choose trust. But our goal is to educate you and empower you, and you decide what's right for you once you understand the pros and cons. So the third thing that a will is not doing for you is that they do nothing for incapacity. They don't do anything until you die. There are documents you need for before you die that you need to have in place as part of a complete package. And as I mentioned, most adults will be incapacitated for some time before they die. It could be permanent, like with dementia. It could be temporary. It could be related to illness, say COVID for a few weeks, short term. In any event, everybody over 18. So if you have young adults, even 18-year-olds, it's important to have these papers in place, because if you don't, it's much more expensive and much more hassle to have to go to court. Okay, so if making your own decisions about your healthcare is important to you, then this will be important. I know people, especially with COVID, are even more concerned. I had someone tell me recently, I've learned I don't want to go on a respirator. I want to put up my healthcare directive, whatever. Wherever you're at, if what you want for your healthcare is important to you, then you want to have a healthcare directive so that you can plan ahead. I want to tell you another little story about a gentleman who contacted me about 6 years ago. He was about 60, pretty young. But his wife had early onset dementia. She had been diagnosed the year before. And so he called, he was very responsible. And he said, I've been knowing for a year I need to update the estate plan. And I just haven't gotten to it. I'm working and taking care of my wife. And now she took a turn for the worse. You know, her capacity just declined suddenly. And so they took her to the doctor and had a battery of tests and confirmed, like, yes, she really had a nosedive. And he said, now I'm afraid it's too late. She doesn't have the ability to understand and sign the papers. And I assured him we could help. And I said, why don't you just come into my office and we'll have a conversation, no pressure, and I'll be assessing where she's at. He called back and said, Margaret, I don't want to make her do it because it was hard for her to go to the doctor's appointment. He was a little worried about it. I said, okay, well, you come into the first meeting. So that's how we did it. He came into the first meeting without her. He saw that it wasn't a problem. They both came back in together and explained what he was really worried about, both before and after she died. He was very concerned that things get put together. And so if you fast forward about, it was probably 2 weeks, they were sitting in my office smiling. Their daughter was there. They got all the papers signed. Everything was all set up. And the reason is he overcame his feelings of like, I should have done this sooner. I'm beating myself up. I feel bad. He just made the phone call and he came in and he did the smooth sailing system and we got all these papers in a row. And so everything went smoothly for them. I was really happy. And I was especially happy because if she didn't have capacity anymore, we might have to go to court, pay the money, have the hassle, but put her on the witness stand with a judge when he was worried about her even coming to my office. I would hate to have to put her through that. So we were very happy that they saved all that expense and hassle and got everything protected. So some of the documents that they had were the healthcare directive, again, which is the one that helps you with your healthcare. So you're going to both appoint an agent, and I recommend you add ideally 2 backups even, so that your document will last a long time, that they can make decisions if your doctor says you can't. And secondly, you're going to give some instructions about what you want for healthcare. I want to highlight from Minnesota that in August of 2016, there was a change. And I have not seen a provision for this in any of the free healthcare directives that I've seen. I don't even see it in all the lawyer healthcare directives, although most of them have it. If you need any kind of treatment that will affect your mental health, let's say when my dad had depression because of his meds, he started to get anxious. And he needed some other meds to help him become less anxious, which we were happy to give him toward the end. And so if you want your loved ones to be able to make those decisions for you and make sure you're getting good care, then that needs to be spelled out in the healthcare directive and have 2 witnesses sign it instead of a notary. So that is part of what we do with our healthcare directive. And I just want to highlight that because a lot of people don't have that updated language in there. That's really important. The next document is all about finances and legal matters. It's called the power of attorney. You probably heard of it. This authorizes someone to take care of your affairs, especially after you lose capacity and while you're still alive. And so you want to appoint people that you trust to take care of your affairs so that they don't have to go to court and get appointed a conservator. If you don't have a healthcare directive and power of attorney, someone will need to go to court and be appointed a conservator and guardian, and that will cost thousands of dollars. So this is really reasonably priced insurance, I think. The third document is a digital asset authorization. This one you maybe never heard of. This is also new from August of 2016 in Minnesota. And at that time, it was sweeping across the country because people realized there was a huge need for it and there was no legal way to do this. There was a couple in Minnesota and they sent their son, Jake, off to college at the University of Minnesota and then sadly, right after his first semester, he died. They found him frozen in the morning, a cold December morning, and they weren't really sure what happened. And the phone was near him by the river. And so it was tragic and horrible. And the family wanted to see his phone for his last messages and photos and kind of find out what happened. And the phone was paid for by the parents on the parents' plan, and same for his laptop. And they had no authority. They had no permission. So they never got access. So they were part of the big push in Minnesota to get this passed so that now you can do this. You can authorize your personal representative, the people after you die or before you die, to bank online for you or access assets online or get something they need off your phone. So that we include in our smooth sailing package as well. So that's a third important paper besides your will that is important to have. Okay, we have another client testimony here. Somebody who contacted and researched many lawyers. Her mom needed a power of attorney and trust updated from Florida to Minnesota. So we often help people who move. And she was impressed with our website. And when she contacted us, she talked to Megan, who is the person that you have that life and legacy session with, and who's also on this presentation. And Megan was very helpful and welcoming, and she chose us and felt like it was a great choice. Did not feel like a typical lawyer's office. I just love that. She felt like they were with friends who wanted to make sure you had the correct power of attorney and trust we needed. That's very true. She said we were very organized. It was fast and easy process, and she recommends us highly. So I really appreciate that. We try to make it as easy and fast as we can. So please be like writing down and remembering your questions right now, because we want to address them in that life and legacy session. And the sooner you schedule it, the better, because it will all be fresher in your mind. We found that people get more value out of the free session if you do it soon, because I know I'm giving you a lot of information. I talk a little bit fast and don't expect you to remember it all. I just really want you to remember that you need to move forward and give you a couple free action steps that you can get started on. That is my goal. So how do you move from being stressed out and possibly overwhelmed by all I'm telling you to having your ducks in a row and having that peace of mind that we really want to give you and that these other clients are talking about? So the best thing to do is to have a life and legacy session with Megan Swenson. This can be on Zoom. It can be in person. We have plexiglass shields in our office and masks and things. So what works for you is good. Actually, most people are doing them on Zoom right now, and we have developed really good systems to do it that way. So you would sign up for a time with Megan, and she is going to really show interest in you by asking what's your concerns, what brings you here today, what are your goals, what's your situation? You know, it's confidential, and we're going to need to know what's your finances, what's your health, what's your family, you know, what are you worried about? Once Megan really has a good understanding of that, she can take you through the pros and cons of a will and a trust for you, really in a custom way. And then she can answer other questions. She can explain our process, which you can kind of see right now on the slide, the smooth sailing estate plan system. And so that, and then she can explain the cost. And then you can decide what you need. And if you're ready and we're a good fit, then you can hire us and we can move forward. Then the burden shifts to us to really help you get your plan in order. So the Life and Legacy session, we encourage you to sign up, and you can go to our website and see, this is a picture of Megan, a Director of Client Relations. Okay, and then on our website, safeharborostatelaw.com/schedule. That's where you can go in and choose the Life and Legacy session. So that's a 45-minute session, and that's the longer free session that we offer because you'll need that for estate planning. Choose that and pick a time that's convenient for you, and Megan will be available to answer the rest of your questions. So I want to thank you very much for joining us today. I hope that you found this helpful. We want to add value in every interaction that we have with people. And I have one final story for you about smooth sailing. This yellow canoe looks a lot like the one my family had growing up. We had 8 kids in my family, and we camped and for our vacations. So we were one time out at Lake Rebecca in Minnetonka camping, or it was a lake near there, but it was a lake that was all natural with just one dock. So my sister and I took this little yellow canoe up, and she was about 14 and I was about 13. So of course she was in the back because she was older steering. We head out across the lake, and it was a beautiful day, and we were having a good time, and we were somewhat experienced, so we were confident, and we were like, let's go all the way across. So we went all the way across. Then we turned around and we realized why it was so easy, because the wind was at our back, and all of a sudden we're heading into the wind. Not only that, but one of those really big summer storms that comes up fast was coming across the sky. It was getting dark, it was getting windy, it was getting cold, all of a sudden scary. We weren't even sure we'd make it to the other end, to the dock, before this storm broke out. So we start paddling really hard. I mean, my chest was tight, I was scared. I looked back at my sister, she looked scared, so that made me even more scared. And then, you know what families do when they're stressed? They start arguing. So then we're arguing, and we're just trying to keep this boat straight so it doesn't tip over. And I'm happy to say we made it, actually, before the whole storm broke wide open, and we didn't dump over. And I was so relieved. And I still remember it today. It was kind of traumatic. But I learned from that experience to plan ahead and to maybe turn around sooner and watch the weather. And I haven't been caught in a situation like that since. So my desire is that your experience, and your loved ones too, would be like my first trip across the lake. That was smooth sailing, and it was fun and enjoyable, and not really like the one back where I was so surprised by the difficult conditions and was not prepared for them. We want you to be prepared. We want you to lay your head on the pillow at night knowing that you've done what you can to protect yourself and your loved ones. Thank you so much for watching today. We appreciate it.